From the daily list, fixed case item 4, MA 252 of 2023.
What is this? This is the case under the Railway Act. Look, what this document you have produced. ये कौन है? ये document. अच्छा इसी में. Appellate. He was traveling. The facts is that the appellant was traveling from Shankarpur to Madhupur station, and he had boarded the Baidyanath from Asansol to traveling from Shankarpur to Madhupur. Baidyanath Dham station to Madhupur station. Shankarpur. No. He had purchased journey ticket from Baidyanath Dham to Madhupur. But now to Madhupur. He had boarded the Baidyanath Dham Asansol PMU passenger. So, PMU passenger on 12/12/16. 12/12/2016. Time. At 5 p.m. 5 p.m. He boarded at Baidyanath. The said ticket was also purchased in Pessimist. Any platform number given? The said ticket was purchased in front of several villagers who had also gone to offer their wares at Deoghar. Ticket was purchased. Ticket was purchased in front of other villagers also who had also gone to offer their prayers at Baidyanath. Purchased in front of other villagers. One of them has been examined and he is Bullu Das. Only one has been examined amongst many. Anyways, Bullu Das was examined. He was a co-passenger? He was a co-passenger, but he was traveling independently. He was also traveling independently. By the same train? Did he produce his ticket? The ticket was lost. Bullu's ticket was also lost. When they come down from the train, then they have to give the ticket to the TT. Hand over the ticket? Yes. ऐसा तो हम लोग को नहीं ऐसा नहीं होता है ऐसा नहीं होता मैडम आप ट्रेन में नहीं ट्रैवल किए हम बहुत ट्रैवल आपको कोई आइडिया नहीं है ट्रेन ट्रैवलिंग का आप फ्लाइट में ट्रैवल करते हैं when we come out of the station the TTs are there they check it but they don't take it they have no business to take it back because that is a proof of traveling he has not produced that ticket yes आपका बोर्डिंग पास ले लेते हैं सीज हो जाता है नहीं होता है ना ना आपका टिकट सीज होता है ना आपका बोर्डिंग पास सीज होता है ना आपका ट्रेन का टिकट सीज होता है इट्स अ प्रूफ ऑफ ट्रैवलिंग this incident was again Bullu Das also did not produce the ticket 2019 the proceedings in this started 12/12/16 hold on please let me just see the circumstances the passenger did not produce the ticket Bullu Das the co-traveler also did not produce the ticket कौन से क्लास में नहीं ट्रैवल किए सारे क्लासेस में हम ट्रैवल किए ठीक है थोड़ा एक्सपीरियंस है ट्रैवलिंग का
लोग सब क्लास में
जनरल क्लास से लेकर
जनरल क्लास से लेकर
जनरल बोगी से लेकर सब
सबने किए सबने किए आजकल का बच्चा लोग नहीं किए
चलिए बताइए.
And then when the in the meantime when the train started to move and while the train was crossing Kumarbad Rohini station,
Which station?
Kumarbad Rohini station.
Kumarbad Rohini station. Accident taking place at Kumarbad Rohini station.
He told me it's Kumarbad. Kumarbad accident took place at Kumarbad Rohini station, and one Rohit Mishra, we had seen the person falling down from the train.
Rohit Mishra.
The appellant was severely injured in
Just a moment. Had seen him falling down from the train.
station from the train.
From train. Okay. And he was found on the track. Rohit Mishra has been examined. From where do you say this? That he had seen?
The Sanha that he has watched.
Any reason for non-examination?
So far as I am appellant is concerned, Rohit Mishra is somebody who is an independent person. The railway should have examined him. For me to track who is Rohit Mishra, where is because the Sanha was also I had received the Sanha through an RTI. What the police did, what follow-up action the police did in this case, because I was admitted in the hospital from 12/12/16 and I was discharged.
Did the police take your statement?
Yes, it took my statement, but later,
When?
not during the.
Maybe, but your statement recorded by police, where is that?
It is there in the hospital.
Now you have to show me two things. One is the statement of Rohit Mishra, Sana, and secondly your statement to the police. Were you examined before the court? So what you have to prove is that you fell down from the train. That's it. Your leg was severed during the accident or it was severed later on? During the accident. It was run over by a train.
When we fell down, the accident caused. I fell down and the legs got amputated. When a person falls down from the train, obviously when he comes on the track and the train is still running.
How the person will fall down from the train and get into the track? Sorry? पुल हो जाता है, फेंका जाता है,
लेकिन उसके साथ भी
पुल नहीं होता है.
तो amputation तो हुआ है.
That is why I want to know. Amputation track पे हुआ है कि amputation बाद में हुआ?
He was severely injured when he went to the hospital. The doctor said that your condition is such that your legs need to be amputated.
So it was amputated later.
ये नहीं कि पैर कट गया था. गया फिर amputation में कट गया था right leg, right leg. The DRM report, that is a statutory inquiry report.
That is exhibit.
That is a page 60.
Exhibit number बताइए. Exhibit हुआ होगा ना? What is the procedure? It must have been exhibited. GRP diary entry.
DRP
You have to show it from the records, not from your annexures.
Actually, in these cases, summary proceedings होता है, they don't exhibit उस कभी कभी करते हैं कभी नहीं
कोई
करते.
बात नहीं. आप बताइए कहाँ है?
Page 62 of the LCR. एक पेज 9 भी है अगर देखते जाइए तो एक पेज 62 दोनों में अभी आ रहे हैं.
ठीक है, पहले पेज 9 दोनों में सेम रिपोर्ट.
हाँ सेम.
पेज 60. Page 62, yes, I am there.
Key facts.
Yes.
Post Commander Jasiri has submitted a report of untoward incident that on.
बताइए relevant part.
That is the inquiry. During inquiry, the case recorded the statement of one eyewitness, namely Rohit Mishra, son of Ramakant Mishra, when he disclosed that on 12/12/16 around 18:30 hours when he was present at Kandu Bazaar near PKP station area, he heard
आराम से. Don't read for yourself. Read it for them.
During inquiry, DO of the case recorded the statement of one eyewitness, namely Rohit Mishra, son of Ramakant Mishra, when he disclosed that on 12/12/16 around 18:30 hours while he was present at Rohini Bazaar near PKQ railway station area, he heard commotion and on reaching the place, he saw that an injured person was lying in the railway line and a crowd was gathered around him. He also stated that he came to know from the persons assembled there that the injured person jumped down from train number 63561 and the train was in running motion and the victim had cut from the wheel and got unconscious. Later on, the name and address of the victim came to his knowledge as Kishan Puri, age about 45 years, son of Dick Procedural Puri of Nanded, PSC Bihar, District Jammu, Bihar. He had the victim.
He is a hearsay person. He is not that. He came after the incident and he came to know that he was jumping from the train.
Even if so, he has the fact that he was traveling.
He is hearsay. You can't rely upon this. What else?
Then the fact is that the Sanha was registered. He got injured as a result of the falling down from accidental fall from the train.
You have to show us accidental fall. He got injured, there is no dispute. He was found on the track, there is no dispute. There is no dispute on that.
Once,
You have to show the fall, that is the crux of the matter.
yes, but the
And the onus is on you as per the Supreme Court's judgment as relied upon in the improved judgment.
statement of Rohit Mishra, next page of the PI report.
Okay. Rohit Mishra. Statement of Rohit Mishra. The same person, right? Yes, please.
On date, he was later examined. Even the statement of Kishan Puri is also there. Kishan Puri का पहले report.
आपको जिसका बोलना है.
On date 26/3/2019, Sri Kishan Puri, aged 45 years, son of late Khudla Puri, president of Nagpur, Bihar, was examined in connection with his claim who stated before JP Radhan, an inquiry officer, that he was working as a laborer in railroad construction in Chopra city. On 12/12/16, while he was returning to his home, ex-Bhagna Gram, Sinutala, he purchased railway ticket from DT.28.07.2025 railway station for Sinutala and boarded in TNE passenger train. When the same train departed from Kebbi station, when he realized train was going towards Hassanpur and was going
ऐसा आधा इतना तेजी से नहीं पढ़ी, इतना तेजी से मेरा दिमाग रजिस्टर नहीं करता। When the state train departed,
from KTP station, then he realized that the train is going towards Asansol and he is going in wrong direction. Without any thought, he jumped out from the train and was literally platform that moved and got unconscious. When he gained consciousness, found him in Sadar Hospital.
if a person jumps down from the train, then also is entitled for
He
compensation.
has got.
This is a statement.
This is a statement in 2019. They have not taken any statement in 2016.
Forget it. It is his case.
Even if there are judgments to that effect, that even if a person has gone into a wrong train and he tries to deboard from it, and he in the process he meets with an accident, then also he is liable to get.
तो जजमेंट दिखाइए ना कि ट्रेन से खुद कूद जाएंगे तो भी उनको compensation.
They have to prove that it was criminal negligence. The railways, then there are the incident in 124 is.
Madam, when you say that there are judgments, please show me the judgments. I will not believe your statement like that. Show me the judgment if a person jumps down from the train himself.
Jumps down from the train.
This is what he is saying.
He is saying that the leadership here, please, this is not a.
Madam, I do not know mercy
124 is-
beyond law. If the law is in your favor, I will give you the sky. I don't know mercy beyond law.
इसका affidavit देख लिया जाए.
Affidavit से क्या होगा? इनका statement recorded.
DRM में they have recorded the statement. But my specific case is that I have accidentally fallen down from the passenger. My case is that I have accidentally fallen down from.
This statement has been wrongly recorded.
This has been wrongly recorded.
Where have you stated so?
I have stated in my.
Before the court, where have you stated that this statement was wrongly recorded? And you never made this statement.
Do you know by your own mistake you travelled in a wrong train? No, I travelled in a right train. Yes,
Where is that statement?
that is on court. Kishanpuri.
That is before the trial court, no? No, that is not sufficient. You see, there are two stages where your statement could have been recorded. One is before the DRM, these officers. Other is at the by the police or railway protection police. In the case diary could be a statement.
And then the railway police, so I have given that Adhikshak Mohoday when I have asked for that Sanha. I have also given my statement. निवेदन ये है कि मैं किसी.
आप कहाँ से पढ़ रहे हैं? मैडम, जो चीज़ रिकॉर्ड में नहीं है उसको मत पढ़िए, हम नहीं पढ़ पाएंगे. I will not be able to read that.
पुलिस को अधीक्षक कर दिया. Page 2 of the
Page 2 of the
NCR. पुलिस अधीक्षक का.
page 2 of the NCR. Yes, madam. This is notice for appearance.
सूचना अधिकार अधिनियम 2005 के अंतर्गत.
Page 2 of the NCR is notice for appearance.
पुलिस अधीक्षक का ये है.
आप NCR बोले ना, NCR का page 2 is notice for appearance. What else do you want to know? This is notice for appearance.
बैक साइड में पेज 49 के बैक साइड बैक से देखिए पेज 49.
40.
47,118 का
47 का बैक साइड
49.
दिस इज 3319. इनको जरा बताइए कौन सा डॉक्यूमेंट है दिखाना है. Please show it to me. Mark that document. Yes. Read it, please.
उपरोक्त प्रसंगाधीन विषय में संदर्भ में सादर सूचित करना है कि आवेदक श्री मनोज निखिल सुभाष शिरा द्वारा जख्मी किशोर पुरी पिता कुबलाल पुरी साकिन नगवे थाना सिमुलतला जिला जम्मू बिहार के संबंध में दिनांक 12/12/16 को घटनास्थल रोहिणी स्टेशन जसीडी के आसपास इसका मेमो रिपोर्ट एवं सच्ची प्रतिलिपि का सत्यापित कॉपी की मांग की गई है. इस संबंध में रेल थाना जसीडी का थाना बॉडी का अवलोकन किया गया. अवलोकन उपरांत पाया गया कि भूसना संख्या 9 दिनांक 13/12/16 में अंकित है कि दिनांक 12/12/16 को रोहिणी स्टेशन के टाउन लाइन के पूर्ण नंबर सच के पास एक घायल व्यक्ति पाया गया था जिसका नाम किशोर तुरी पिता कुबलाल तुरी साकिन नगवे थाना सिमुलतला जिला जम्मू बिहार है. इस संबंध में त्वरित कार्रवाई करते हुए सिमुलतला थाना जिला जम्मू को सूचित किया गया था. उचित उपचार हेतु सदर अस्पताल भेजकर भेजा गया था. इस घटित घटना के संबंध में स्टेशन प्रबंधक जसीडी द्वारा रेल थाना जसीडी को कोई मेमो प्राप्त नहीं हुआ था. Then the next page, the Sangha is there.
Page 47. This is the sun.
This is the Mool Sangha and then the Mool Sangha.
This is 10/2/2019.
13/12/16 को and then 12/12/16.
आप नेक्स्ट पेज बोलिए, वो पेज नंबर कौन सा है?
Next page में सना होगा, 2 सना होगा.
एक 26/3/19 है.
का जो पुलिस अधीक्षक का भी पढ़े.
उसके आसपास तो नहीं है.
उसके बाद नेक्स्ट में नहीं.
आपके पास एनसीआर का सॉफ्ट कॉपी नहीं है. पेज नंबर भी आपको बतानी है. लीजिए उनको फिर से बताइए कौन सा पेज. इनको एनसीआर प्रोवाइड करिए सॉफ्ट कॉपी. ठीक. But this is 4/1/18.
180, but it was
Date of
registered on
incident is 12/12/16.
They have registered it on 12/12/16 itself. The dates are mentioned there.
That's right. Read it, please.
इस समय मूल समा दर्ज करता हूँ दिनांक 12/12/16 को समय 18:30 बजे रोहित मिश्रा पिता स्वर्गीय रमाकांत मिश्रा साकिन रोहिणी थाना जसीटी जिला ग्वालियर के देवघर में मोबाइल फोन के माध्यम से सूचित किए कि वह रोहिणी हॉल्ट में डाउन लाइन पर एक व्यक्ति घायल अवस्था में पड़ा हुआ है जिसके ग्रामीणों के सहयोग से सदर अस्पताल देवघर इलाज हेतु लेकर जा रहा हूँ. सनहा दर्ज किया. इसके सत्यापन हेतु एवं आवश्यक कार्रवाई हेतु केशव प्रसाद शर्मा सदर अस्पताल देवघर के लिए प्रस्थान किए. नेक्स्ट इज मुझे इस समय मूल सनहा दर्ज करता हूँ कि ये सनहा दिनांक 12/12/16 को समय 9:30 बजे करना था परंतु भूलवश छूट गया था जो कि सनहा निम्न प्रकार था. साकिन केशव प्रसाद शर्मा सनहा नंबर 8 में सत्यापन एवं आवश्यक कार्रवाई से थाने वापस आए और साथ में रोहित मिश्रा पिता स्वर्गीय रमाकांत मिश्रा साकिन रोहिणी थाना जसीटी जिला देवघर का सदर अस्पताल देवघर के आपातकालीन में लिया गया था बयान जो निम्न प्रकार है और बताए कि रोहिणी स्टेशन के डाउन लाइन के पोल 1728 के पास एक घायल व्यक्ति को पाया गया है जिसे रोहित मिश्रा एवं ग्रामीण कुंदन पांडे पिता स्वर्गीय दिलीप सुनील साकिन रोहिणी थाना जसीटी जिला देवघर द्वारा सदर अस्पताल देवघर में भर्ती कराया गया है जहाँ पर इलाज चल रहा है. आगे बताया कि समय करीब 17:50 बजे घटना धाम आसनसोल येलो सवारी गाड़ी रोहिणी स्टेशन से खुलने के बाद घायल व्यक्ति वहाँ पड़ा हुआ था. इस घटना में किसी का कोई दोष नहीं प्रतीत होता है. घायल व्यक्ति का नाम किशोर पुरी उम्र 50 वर्ष गरीब पिता कुलर पुरी एवं नागेश्वर थाना सिंह थाना जिला जमुई बिहार है. सूचना थाना प्रभारी सिमोतलाल मेलो के माध्यम से दिया गया है. Now, if I may go to the Rina Devi case.
What is it?
Railway pen license will not be.
Madam, you will not provide me a copy. Yes, read. This was technical. Yes, madam. What were the facts of this case?
The facts of this case was also.
Read it, please.
This appeal has been referred against the order of compensation of rupees 2 lakhs under section 124A observe the improved judgment, irrespective of its characters, and be proposed to consider multiple issues not to be raised and the issues that have been brought to our notice to the table of the issue. While order dated 13th March 2018 to notice the issue of apparent conflict in Rati Madam versus Zuluva Vidya and Kalani Charan Sahu versus General Manager South Eastern Railway, Bilaspur, as to the relevant dates of applying the rate of compensation, a different date is applicable at the time of filing of claim and the date of the order. A submission has been filed with the registrar of principal bench, railway claims tribunal seeking clarification on 4 subjects which repeatedly arise before the secretary. Quantum of compensation is stated that there is conflict in the decisions in Rati Sutra and Kalani Charan Sahu Sutra, which needs clarification. We have already taken out the decision. Definition of passenger. Whether the person found that the track.
Yes, we have seen the facts. Which paragraph are you referring to? Which paragraph are you relying on?
I am relying on
Which paragraph?
$16.2.
16.2.
One of the paragraphs on the 16.2. Coming to the proviso to section 124A, to the effect that no compensation is payable if a passenger dies or suffers injury due to situations mentioned therein, there is no difficulty as regards suicide or attempted suicide, in which no compensation will be paid. Conflict of opinions manifests as arising from understanding the expression self-inflicted injury in the proviso. In some decisions, it has been held that injury or death because of negligence of the victim was at par with self-inflicted injury. We may refer to decisions of efforts of Kerala and Joseph Kuti and Bombay, and Pushpa and Delhi and Shyamdara and Hindustan. In Joseph Kuti, the victim received injuries in the course of continued.
It is the finding of the court. This is
There were
again the
several
discussion.
issues, this particular judgment, because there was various anomalies with respect, because the issues so far as Railway Act are concerned are only to that extent, because the Railway Act is based on the principle of no fault liability, it is based on the principle of strict liability, it is not based on the principle of contributory negligence. And 124A says that irrespective of no negligence on the part of the railways, once it is found that the person is a bona fide passenger and the person is has met with an accident and untoward incident, railway is bound to compensate the passenger for the said accident.
I think you
And
please complete the
124A
reading of this judgment. This 16.2 is just talking about conflicting views.
conflicting.
What the Honorable Supreme Court has ultimately crystallized in this judgment. If there are conflicting views, the Honorable Supreme Court would have crystallized the view. Where is that paragraph? You just tell me that.
Para 17.3.
As 17.1.
4.
We have 17.1. Where is 17.4? Second last
Para
step.
8.
Where is 17.4?
Rate of interest, we just tell them that before the rate of interest.
Rate of interest, उसके just पहले.
We does 4.
Okay.
It is said that mere presence of a body on the railway premises will not be conclusive to know whether injured or diseased was a bona fide passenger for which claim for compensation will be made. However, mere absence of ticket with such injured or diseased will not negative the claim that he was a bona fide passenger. Initial burden will be on the claimant, which can be discharged by filing an affidavit of the rental facts, and burden will then shift on the railways, and the issue can be decided on the facts shown or the attending circumstances. This will have to be dealt with from case to case on the basis of facts found. The legal position in this regard will stand explained.
That's right. So your affidavit was filed before the court. What was your affidavit? Have you been cross-examined on that? What was your main petition? Let us see your petition. Where is your affidavit?
Page 38 and 39.
And what is page 45? Statement of Guru Das. Your affidavit is at page number 45. Statement of Kishun Turi, AW1.
Affidavit of Kishun Turi is on 38 and 39, and then the statement.
Affidavit at page 38 and 39. It is at page number 39 and 40. Yes. मैं घायल
Kishun Kishun Turi पिता स्वर्गीय फुटबॉल खेल उम्र लगभग 44 वर्ष निवासी ग्राम नावड़े थाना सिमोटला जिला जमुई सत्य एवं निष्ठापूर्वक बयान करता हूँ जो इस प्रकार है यह कि मैं आरसीटी केस नंबर 19 का घायल आवेदक हूँ यह कि देवघर में भोले बाबा का दर्शन करने के बाद दिनांक 12/12/16 को मैं बैद्यनाथ धाम रेलवे स्टेशन से शंकरपुर स्टेशन तक का तृतीय श्रेणी का साधारण वैध यात्रा टिकट लेकर बैद्यनाथ धाम आसनसोल गेहूं सवारी बैद्यनाथ धाम रेलवे स्टेशन में सवार होकर शंकरपुर स्टेशन और बहन देवी पति बबलू तुरी के यहाँ उससे मिलने जा रहा था यह कि उपरोक्त वैध टिकट मैंने अपने ग्रामीण बेलूदास के समक्ष बैद्यनाथ रेलवे स्टेशन तक खरीदा था बेलूदास ने भी मेरे साथ ही अपने के समतला का वैध टिकट खरीदा यह ट्रेन में काफी भीड़ भाड़ थी जिसके कारण मैं और बेलूदास बाध्य होकर डब्बे के दरवाजे के पास खड़े होकर यात्रा कर रहे थे बेलूदास सिविल डाला जाने हेतु जसीडीह जंक्शन को उतर गया यह कि जसीडीह जंक्शन में और यात्री के बढ़ चढ़ने से मेरे डब्बे के दरवाजे के पास ज्यादा भीड़ भाड़ हो गई जिसके कारण बहुत धक्का मुक्की यात्रियों के बीच होने लगा यह कि रेल यात्रा के रास्ते में जब ट्रेन कुमार भादोही स्टेशन से खुली थी तो मैं जो कि भीड़ भाड़ के कारण बाध्य होकर डब्बे के दरवाजे के पास खड़े होकर यात्रा कर रहा था यात्रियों की भीड़ से हो रही गहन धक्का मुक्की से दुर्घटनावश चलती ट्रेन से पोल से 317 के पास गिर गया जिससे मेरा बायां पांव पूरी तरह क्षतिग्रस्त हो गया और मुझे अन्य गंभीर चोटें भी लगी यह कि स्थानीय लोगों ने मुझ घायल को इलाज हेतु सदर अस्पताल देवघर पहुंचा दिया जहाँ पर मेरे परिजन दुर्घटना की सूचना देने के लिए पहुंच गए जहाँ मेरा इलाज चल रहा था यह कि मेरे उपरोक्त वैध टिकट जिसे मैंने अपने ग्रामीण बेलूदास के समझ में लिया था वह ट्रेन दुर्घटना के बीच मुझे घायल को घटना स्थान से उठाने इलाज हेतु अस्पताल ले जाने के क्रम में इधर debit is there on record.
Yes, respondent. He has fully supported his case. You could get nothing out of his cross examination.
The one thing I would like to proceed mechanism here. First of all, the section 124.
Railway Claim Act.
Railway.
Railway Act.
Yes. When he is not liable for compensation.
124.
124A.
124A.
Provided that no compensation shall be paid under this section by the railway administration if the passenger die or suffer any injury due to suicide or attempted suicide by him. So the case is there is very thin line between the wrongful act of negligence and the jumping from the train. Jumping clearly established.
He did not say that he jumped out.
That say
No,
the
in
DRM's
his
report.
evidence, DRM's report is not a gospel truth. Right? You should have confronted with him that in DRM's report, this is your statement. You have not confronted you see, you could have contradicted his statement by his previous statement. Right? You should have shown that previous statement to him. How do you rely upon the report of DRM and the statement given in the report of DRM? You do not show it to him that you had given a different version at any point of time or there was some other evidence at any point of time.
There are two things. If he is the bona fide person, the first of all, although he filed affidavit, in view of the Rina Devi's. But
He filed an affidavit. That affidavit is also supported by Bundu Das, who said that I had also purchased a ticket and I was traveling in the same train, but I got down early.
Yes, it's true, but
And if there are more than required passengers in the train, you should have asked him to come down. What's the big deal? आप इतना टिकट बेचते क्यों हैं? कि आर्मी के ऊपर आर्मी चढ़े?
उस स्थिति में मौजूद तुम इसको तो मिलेगा ही, लेकिन बट फैक्ट लॉर्डशिप में काइंडली कंसीडर तो रीना देवी केस इज नॉट the 100% the honorable Supreme Court saying that once the affidavit is filed then he is liable for compensation.
No, it's not that. Every fact is to be taken into consideration.
Now I am placing the lordship can see the petition the page
His
annexure
petition.
1. Yes.
Annexure 1.
Yes.
What petition is that?
Appeal.
LCR का part है.
No, appeal. MA. Petition filed by the petition. Appellant MA. Annexure 1, page 22.
It must be a part of the record, I suppose.
No, that is the claim of it.
Yes. Page number
22.
22. Okay.
Now, very particular the untoward incident indicating the date and place of the accident.
Yes.
I am reading. On 12/12/2026, after purchasing a valid 16, after purchasing and having a valid second-class ordinary ticket for Bagnat Dham station to Madhupur, Junction 1, the injured applicant, namely Christian registration to the said, it has been subsequently added, the said valid ticket was purchased by the injured in presence of some villager, after worship of lordship, in presence of some villager. Lord, here, Lord, although Lord, this claim application was filed in the year of 2018, occurrence took place in the year of 2016 after 2 years. My Lord, he has not disclosed the name of Bullu Das, my Lord, here.
पढ़िए इसको पढ़िए.
Yes, Lord. Vednath Dham, Asansol Yemi passenger train for going to Madhupur Junction. There was heavy rush on the side train which compelled me to stand near the gate inside the bogie. The passengers were jostling one another for space near the gate of the bogie in view, while the side train started and moved forward from Tumarabad Rohini Station 1. The injured who was standing near the gate inside the bogie accidentally fell. Lord, in his statement, Lord, or affidavit, Lord, he says he boarded in the wrong train, Lord. He tried to deboard, Lord.
In which statement?
Lord, yes, it is.
No, it does not come that he boarded on a wrong train.
Okay,
Cross examination में पूछा है which he denied. He said that I boarded on in the right train.
From place कर देंगे.
Place
He was reading. From the moving train near such and such down line, station due to the intense jostling among the passenger near the gate of the bogie on account of heavy rush. As said, as a result of which I, the injured, lost my one leg, and also sustained other injuries, serious injury. The local people admitted me in civil hospital level for my treatment. After getting information, my family member reached the same hospital where the treatment was going on. In this regard, SD Sanha number such and such have been registered for the time. Now, Lordship may kindly see, Lord, the first part is, my Lord, he has not named, my Lord, so far as the Bullu Das is
The
concerned.
name of Bullu Das is not mentioned.
Yes, Lord,
In
now,
his claim.
page 27. That is, my Lord, the son. इस आशा सन्हा मूल सन्हा दर्ज करता हूँ कि दिनांक 12/12/2016 को समय 18:30।
ये तो पढ़ लिया पूरा, इसमें क्या पढ़ना?
हाँ, इसमें जो हम बता रहे हैं, मूल सन्हा दर्ज करता हूँ, सन्हा नंबर सच करता हूँ, परंतु भूल वह छूट गया था, जो कि सन्हा निम्न प्रकार है। व्हाट वाज द मतलब दो सन्हा? सहायक आरक्षी निरीक्षक केशव प्रसाद वर्मा सन्हा नंबर की स्थापना में आवश्यक कार्रवाई से थाना वापस आए और साथ में रोहित मिश्रा पिता सज्जन सर जिला देवघर के आपातकालीन में लिया गया कर्दव्याल आपातकालीन में लिया गया कर्दवान लाए जो निम्न प्रकार है। बताया कि रोहिणी स्टेशन से सज्जन सर पोल के पास एक घायल व्यक्ति पाया गया जिसे रोहित मिश्रा एवं ग्रामीण कुंदन पांडे सचिन सर देवघर में भर्ती कराया गया, जहाँ पर इलाज चल रहा है। आगे बताए कि समय इतना बजे बैद्यनाथ धाम आसनसोल खुलने के बाद घायल व्यक्ति वहाँ पड़ा हुआ था। इस घटना में किसी का कोई दोष नहीं है। नाउ मिलोड दिस रोहित मिश्रा इज नॉट द आई विटनेस।
He is not the eyewitness. He came later.
He came later.
He cannot say who fell
And
when.
he has supported only to the extent that a person.
He was found on the.
Now Lord can you see the report of the DRM's report and the RPF police officers.
देखिए वो सब रिपोर्ट का बात कर रहे हैं, जब आप उनको कन्फ्रंट करें, victim comes, makes a statement, you cross examine, and you do not tell him that report is otherwise. You do not tell him that there was a different version earlier. कुछ नहीं.
Because fact is the occurrence took place 2016. 2018 he filed a claim application. He has not given the details with respect to the incident and so far as the ticket he has lost. All these things, name of the Bullu Das were not in the claim application. Subsequently, this has been all this witness and the fact has been created after filing the affidavit. This is my submission. issue my lord the which 7.2 paragraph 7.2.
Where is the cross examination of Guru Das?
Page 45.
45 of this memo copy
No,
of the NCR.
it's not.
पढ़िए जरा. Please read it.
Yes, I will do. प्रश्न 1 ये आपका शपथ पत्र है जिससे आपने अपना हस्ताक्षर किया है जिससे जो भी लिखी हुई है वो आपके गैर अनुसार इसे पढ़कर अपने संबंध का प्रश्न इसी दूरी और आप महिला काम में मजदूरी करते हैं जिन्हें पूजा करने के लिए घटना होते हुए आप नहीं देखते थे जी हाँ नहीं देखते घटना कितने देर होता ये भी हमें नहीं देखते आप टिकट कटाते हुए भी किसी दूरी को नहीं देखते आप दोनों साथ में टिकट कटाए घटना कैसे हुआ आप नहीं जानते मेरा कहना है कि कोई जरूरी व्यक्ति आपका दोस्त है इसलिए आपने फायदा दिलाने के लिए उसे झूठी दवाई ली ऐसी बात नहीं
अब ट्रायल को मतलब ट्रिब्यूनल ने कैसे दिया है, कैसे डील किया इन दोनों के एविडेंस को?
Yes, look, the starts from page 36.
बॉटम से पढ़िए. इशू नंबर 2 3
Issue number 2, 3 and 4. Look, it is very important. The above three issues are taken up together for the sake of in the claim application. The applicant at the column number 7 stated that he was traveling with a valid second class ordinary ticket from Badnath Dham station to Madhupur Junction on 12/12/2016, which was lost during the incident. During cross-examination, the applicant appeared as witness interview 1, and on question number 12, specifically answered that he was traveling alone. Just after this question, he also stated that Sri Guru Das had seen him buying a journey ticket, who was traveling with him and was going to the city. But the bench note that the name of Sri Guru Das nowhere appear in the original claim application. There is contradiction in the statement. Sri Guru Das, in support of the claim, also appeared at page 2 before this tribunal and stated on the proof that they had taken the tickets together individually. He had to go to Simultala. So he got down at the city junction. It therefore appears that Sri Guru Das has said this for the first time during his deposition only to get the court to grant compensation in favor of the applicant. The deposition of AW2 is not reliable and cannot be acceptable. As per RPA version, the injured person was admitted in the Civil Hospital Delhi and discharged on 21/3/2017. In support, the applicant has submitted a photocopy of the same, and after 1 year of this claim is made. Their finding of the dead body injured person near the railway track does not ipso facto prove that the dead or injured person is a victim of the falling down incident. The position of law is made clear from the judgment in Union of India versus such and such, which is as para 17.4 in the judgment of the Supreme Court of India in Union of India versus that mere presence of a body on the railway premises will not be conclusive to hold that injured or the deceased person was a bona fide passenger. Initially, burden will be overflowing, which can be decided on the facts shown or the attending.
What you have to say that you have not disclosed the name of Guru Das in your claim application.
Your application will check the law sets in motion.
Sorry?
The law, like, he has filed the claim applications stating everything that how this untoward incident has happened. Thereafter, there villagers are there.
No,
Who will come forward and who will not come forward is also something that the claimant is not aware of. He knows that these are people, and then Gulu Das says मिल जाता है कि हाँ ठीक है हम थे उस दिन पता चलता है, and he has brought him on as evidence. He has filed affidavit also. Gulu Das affidavit is also there on that. So it is for an individual who has injured or एक को जाके बोलना, it has becomes difficult. And I'm also relying on this very significant judgment of Union of India versus Prabhakar and Vijay Kumar, which
which paragraph?
11.
Para 11. Yes.
No doubt it is possible that two interpretations can be given to the expression accidental falling of the passenger from a train carrying passengers. The first thing that it only applies when a person has actually got inside the train or the force down from the train. And the second thing that it includes a situation where a person is trying to board the train and force down from the train. Since the provision for compensation in the Railway Act is a beneficial piece of legislation, in our opinion, it should receive a liberal and wider interpretation and not a narrow and technical track. Hence, in our opinion, the matter of above mentioned two interpretations, the one which enhances the object of this matter and serves its purpose should be taken. In our opinion, if we adopt a restrictive meaning to the expression accidental falling of a passenger from a train carrying passengers in section 123C of the Railways Act, we will be depriving a large number of railway passengers from getting compensation of railway accidents. It is well known in our country that there are crores of people who travel by railway trains, since everybody cannot afford traveling by air, train or private car. By giving a restrictive and narrow meaning to the expression, it will be depriving a large number of victims of train accidents, particularly poor and middle class people, from getting compensation under the Railways Act. Hence, in our opinion, the expression accidentally falling of the passenger from a train carrying passenger includes incidents when a bona fide passenger traveling with another ticket or class is carrying entering a railway train without time during the process. In other words, a purposive and not literal interpretation should be given to the expression.
Sorry?
Statement of basically
There are only two persons are there.
paragraph 4.
Paragraph 4 of
Sorry, page 4.
Page 4 of
LCR. इसमें किसान पूरी का बयान है. Page 4.
Page 3, page 4 तो नहीं है. कहाँ इनका बयान?
Page 4.
Of LCR.
आपका
But your lordship take
Page 4 में तो वो है.
आरपीएफ का जो DRM रिपोर्ट के बाद जो इंक्वायरी
Checklist.
आरपीएफ का जो इंक्वायरी
हुआ था जो जिसमें क्वेश्चन पूरी
इनका स्टेटमेंट लिया.
Checklist.
हाँ.
Checklist.
नहीं, आरपीएफ का जो इंक्वायरी हुआ
अब वो पेज 4 में तो नहीं है.
पेज 4 में है. Inquiry conducted by RPF.
नीचे जरा इनको.
इसमें भी बोलते हैं गलत ट्रेन में
इनको दिखाएं लैब का स्टेटमेंट
Yeah, because they have not, when they have affidavit, the leadership had already pointed out that during my course, they have not even referred to this particular statement. They have not referred to this statement. They have not said that आपने ये पहले बोला था और ये ऐसा किया है.
it is a part
And
of
they have not put up a case that I had was negligent. वो खुद ही बोलते हैं कि किसी का दोष नहीं पाया गया. That this would amount to criminal. If they have to at all make out such a case, then they have to bring it within the proviso. Let them show in the DRM report that they have said that this case comes within the proviso of section 124. And this is how we have dealt with it. And we have proved that yes, he was either criminal negligence was there, self-inflicted injury was there. There is a particular decision of the Kerala High Court, Your Lordship, in which a person had entered into a wrong train. Even if I am believing that such a thing there has come out. And the person got injured, and here also he met with an accident. There also the Honorable High Court of Kerala held that the person will be. They have not brought the case within the proviso of section 124. In case they have to do that.
चिल्लाने से केस बेहतर हो जाता है
In case they have to do that, they have to bring it within the proviso of 124. They have not done that.
three affidavit my lord,
in the DRM report it is there, your statement is there that
But they have not brought it. They have not asked me that I have made whether I have made that statement or not. They have not crossed me on that point.
that has been filed my lord on
They have.
24 February 2022 my lord. This report has been filed by the railway before the tribunal.
And nowhere in the entire.
And that is a part of the report my lord. That has been considered my lord in the judgment also.
Nowhere in the.
this has been considered in the judgment.
My lord, so far as report is concerned.
Where
But
is the
the
consideration?
stand is my lord.
Where is the consideration?
The report just my lord I am.
No, you said that it has been considered. Where is
The
that
report of the
considered?
DRM report. My lord.
Yes, where is it considered?
Yes. Look, the next page, look the
38. Okay.
GRP diary number such and such, detail such and such mentioned that a person is lying in the injured condition where running on. The GRP case diary does not indicate any incidental fall from a train of an injured person found at the spot near the railway track. The respondents have also no evidence that any person has fallen down from the running train. From a deposition of Sri Guru Das, it appears that he is a planted witness. There is no mention in the train number and the name in the GRP diary entry. Original claim application shows that injured person are travelling by Vednadam Asansol such and such passenger train, which is not adequately established that the injured might have fallen down from a running train. He might have been injured when he was crossing the railway train. There is no evidence regarding fall from any specific train. GRP diary entry only mentioned regarding some body found in an injured side on the railway track.
ठीक है सुनो. MA number 252 of 2023.
In which a person had entered into a train, even if that is to be.
That is not the finding anywhere. MA number 252 of 2023. This appeal has been filed under section 23 within bracket 1 of Railway Claims Tribunal Act 1987 and is challenging the judgment dated 19/4/2022 passed by learned member / technical, Railway Claims Tribunal Ranchi Bench in case number OA bracket capital 11 U II slash RNC slash 35 slash 2019 within bracket checklist number 2901190005 in an application filed under section 16 of the Railway Claims Tribunal, wherein the claim application seeking compensation amount of 8 lakhs along with interest on the date of the incident, that is 12/12/2016, on account of loss and amputation of leg as prescribed under Part Roman 2 Clause 3 of Rule 3 under Schedule in Railway Accident and Claims Compensation within bracket Amendment bracket Close Rules 1990 was rejected, holding that the claimant was not a bona fide passenger and did not get injured in an untoward incident as prescribed under the Railway Act 1989. The learned counsel for the appellant, while challenging the improved judgment, has submitted that the facts and circumstances of the case have not been properly appreciated by the court, and the evidence of two persons, that is the claimant and one Bulu Das, who was a co-passenger in the train but had got down earlier than the time of the incident, as compared to the time of the incident, have been recorded by the learned tribunal, and they have also been fully cross-examined, but their evidence has not been properly appreciated by the court while rejecting the claim. The learned counsel has submitted that the records of the case reveal that Sana was reported on the basis of the statement of one Rohit Mishra, whose statement was also recorded during the inquiry conducted by the railway authorities, wherein he had stated that the incident had taken place on 12/12/2016 at 18:30 hours, when upon hearing commotion, when he was in Rohini Bazaar, and upon hearing commotion, he reached the place of occurrence and saw that one injured person was lying down at the railway line, and crowd was gathered around him, and on inquiry, he was informed that it came to light that the injured person jumped down from the train number 63564 when the train was in running condition and got injured and unconscious. He was taken to hospital for treatment. And ultimately, the learned counsel submits that the arm, one of his leg was amputated. The learned counsel has also submitted that in the inquiry report, the statement of the claimant was also recorded, who by stating that the claimant was that he disclosed that he was working as a laborer in building construction at Degur City, and on 12/12/2016, while he was returning home, he purchased railway ticket ex Badrinath Dham to Simtala, and he purchased a ticket from BTME railway station for Simulata and boarded in DMU passenger train. When the said train departed from KBQ station, then he realized that the train was going in wrong direction towards Asansol, and he was going in wrong direction, and therefore without any thought he jumped down from the train and his left leg cut from the knee, and he got unconscious and gained consciousness in hospital. The learned counsel has submitted that as a result of inquiry, the inquiry officer came to a result, as mentioned in the inquiry report itself, that no substantial proof regarding travelling of the claimant could be found on the date of the incident, and the claimant did not provide the ticket during inquiry. And ultimately recorded that only Rohit Mishra had stated that the injured person was lying in railway track, which cast a cloud of suspicion in his statement, and recorded that the reason for inquiry could not be ascertained. Ultimately, the claim was taken up before the claims tribunal. She submits that before the claims tribunal, the claimant supported his case by stating the facts which was mentioned in the prescribed form, and brief particulars of the untoward incident was indicated therein. She submits that it was a specific case of the claimant that he had purchased the railway ticket, and many local people had seen him purchasing the railway ticket, and due to heavy rush, and he boarded the train, but due to heavy rush he got pushed and fell down and met with injury. The learned counsel has submitted that before the claims tribunal, the claimant had filed his evidence on affidavit and had fully supported the statement made in the claim petition, and has further stated that he had purchased the ticket. He has given the details of purchase of the ticket. And has stated that he had boarded the train and was going to meet his sister. After having darshan at Baba Dham. He has also stated that he had purchased the ticket in presence of his co-villager Billu Das, who had also purchased the ticket for Simultala, and Billu Das got down from the train at Jasudi, and the claimant continued with his journey, and ultimately the incident took place and he fell from the running train. She submits that the witness has been duly cross-examined and his evidence has remained intact. There was no cross-examination of this witness with respect to his previous statement, which was in fact disbelieved by the inquiry officer of the railway authority, who were of the view that the cause of the incident could not be ascertained. She has also submitted that since many villagers had taken ticket, therefore one of the villagers, namely Billu Das, was examined as AW2 before the learned tribunal, and he had also fully supported the version of the claimant. This witness has also been cross-examined and his examination in chief remained intact, and his evidence was, and he had fully supported the case of the claimant. The learned counsel has submitted that the learned tribunal has considered the evidences and primarily based its finding on the ground that the claimant did not specifically mention the name of Billu Das in his original claim application, that Billu Das had also purchased a journey ticket and was travelling with him. The learned counsel had submitted that it was stated in the claim petition that number of villagers were traveling in the train, co-villagers were traveling in the train, and ultimately the claimant had examined Gullu Das, and it was also specifically mentioned in the claim petition that evidence/witnesses will be produced at the time of hearing of the case. The learned counsel has submitted that though the first responder of the incident, namely Rohit Mishra, was not examined before the court, before the tribunal, but he had given his statement twice, one at the time of Sanha wherein he stated that the victim, that is the claimant, had fell down while unboarding the train, and thereafter on 30/3/2019, where again he had supported his statement, although his statement was based on the statement made by the people who gathered around the incident, and strictly speaking, he was not the eyewitness, but he was the first responder. The learned counsel has submitted that the evidence on affidavit filed by the claimant and Gullu Das having remained intact, there was no reason to deny compensation to the claimant. She has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2019 bracket close 3 SCC 572 Union of India versus Reena Devi, and has submitted that in the said case also the deceased had purchased a ticket, but he had ultimately expired and ticket was not recovered from his possession. The Honorable Supreme Court ultimately held that mere presence of a body on railway premises will not be conclusive to hold that the injured or deceased was a bona fide passenger, for which claim for compensation could be maintained. However, mere absence of a ticket with such injured or deceased will not negative the claim that he was a bona fide passenger. And such an issue and initial burden is on the claimant, which can be discharged by filing an affidavit of the relevant facts, and then the burden would shift to the railways, and such decision will be based on case-to-case basis. Paragraph 17.4 ये SCC का जो भी होगा ले लेना of the aforesaid judgment is quoted as under. She has then relied upon the judgment. इसका जरूरत है? Judgment passed by Honorable Supreme Court in the case of Union of India versus Prabhakar, Vijay Kumar and others in civil appeal, within bracket civil number 6892 of 2002, and has submitted that the principle of strict liability applies in a case arising out of claim relating to railway accident. The Learned Counsel, appearing on behalf of the respondents, has opposed the prayer and has submitted that the Learned Court has rightly referred to the improvement made by the claimant inasmuch as the claimant did not disclose the name of Guru Das in his claim application, and has rightly come to the conclusion that the evidence of Guru Das was not reliable. The Learned Counsel has further referred to the report of DRM and has submitted that the claimant had a different version given at the stage of inquiry by the authority, wherein he had stated that he had boarded, though he had purchased a ticket, but had boarded a wrong train. And since the train was going to Asansol, he tried to get down from the running train and ultimately he injured himself and got unconscious.
What is about jumping?
He jumped down from the running train and he ultimately got injured and became unconscious and gained his consciousness in the Sadar hospital. The Learned Counsel submits that
Exceptions of section 124A.
he has referred to the provision of section 124 capital A of Railways Act and has submitted that such an act comes under exception
Self-inflicted.
and it is a self-inflicted injury by the claimant, and therefore he was not entitled, therefore also the claimant was not entitled to any compensation under the Railways Act. He has submitted that the improved judgment passed by the tribunal does not call for any interference. However, during the course of arguments, he has not been able to show any material that the earlier statement of the claimant, that the claimant during his evidence recorded before the learned tribunal was confronted with earlier statement given by him before the inquiry and as recorded in the inquiry report. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the claimant was found in an injured condition on the railway track on 12/12/2016, and he was taken to hospital, and arising out of the accident, his one leg was amputated. It is further not in dispute that the first responder was one Rohit Mishra, who came to the place of, who also lost the Sanha, and at whose instance the Sanha was lost, and who came to the place of occurrence immediately after the incident when he heard commotion, and upon reaching the place of incident, he was informed by the crowd that the injured person jumped from the train, number 63562, which is the same train involved in the present case. Correct? यही है train number. However, this court also finds that, as per the records, the statement of the victim as well as the statement of the first responder was recorded by the inquiry officer of the case, and it has been recorded therein that so far as the claimant is concerned, he stated that he purchased the railway ticket but boarded a wrong train, and when he found that the train was going in a different direction, he jumped from the train. And so far as the statement of Rohit Mishra is concerned, he supported his statement which was made initially. The inquiry report, the inquiry officer ultimately came to a finding that the ticket was not found so far as Rohit Mishra is concerned, so far as the claimant is concerned, and it was opined that the reason of injury could not be ascertained. When the case was taken up before the claims tribunal, the claimant made the following statement in paragraph 6 with the bracket B, which is the prescribed form for lodging a claim, ये page 22 में मिलेगा. Although the claimant had stated that he had purchased a valid ticket in presence of some villagers after worship of Lord Shiva, he boarded the Vaidyanath Dham Asansol EMU passenger for going to Madhupur Junction, and there was heavy rush in the train. But in description of particulars, he had not given the name of any one or the other villager in whose presence he had purchased the ticket. However, in column 18, he had stated that he would produce evidence/witness if required at the time of hearing of the case. Ultimately, when the case was taken up, the claimant had filed evidence on affidavit and stated that he was traveling back. He was and stated that he had darshan at Devghar on 12/12/2016, and he came to Vaidyanath Dham railway station and boarded the train from Vaidyanath Dham railway station to Shankaranpur station within bracket Madhupur under a valid second-class ticket in the train involved in this case, and he was to go to meet his sister. He has also stated that he purchased the ticket along with one Billu Das, who had also purchased the ticket and boarded the train. And both of them were traveling in the train and were standing near the gate on account of heavy crowd. He has further stated that when the train reached Kumarbad Rohini station, when the train left Kumarbad Rohini station, he was pushed and he fell down. He has also stated that he has stated that at the time of accident, Billu Das was not available, and he had, although he had purchased the ticket along with him. He has further stated that during the course of his accident and his treatment, the ticket got misplaced and he was not in a position to produce the ticket. This witness has been duly cross-examined and he has fully supported his case. He has also stated that at the time of traveling, nobody was with him and Bullu Das was actually traveling with him, but he wanted to go to Jasiti and got down at Jasiti railway station. He has also submitted that Bullu Das had seen him purchasing the ticket and the cost of ticket was ₹10 from Devgar to Shankarpur. However, during the course of cross-examination, he has not been confronted with his previous statement said to have been made before the inquiry officer, nor he was put any question regarding any improvement in his statement made before the memory trial. And a suggestion was put to him that due to his own mistake, he was traveling in wrong train, and when he came to know that he was traveling in wrong train, he jumped over. And this suggestion was denied by him. The other witness, Bullu Das, had fully supported the case of the claimant, and this witness was also cross-examined and has clearly stated that both the claimant and Bullu Das got the ticket together and he had boarded the train, and he had denied the suggestion that he was giving false evidence to help his friend. This court finds that the claimant as well as the witness has fully supported the case. They were cross-examined and their evidence remained intact. The claimant was not put any question with respect to, not confronted with his statement, with his previous statement before the learned tribunal, nor the claimant was put any question alleging improvement in his case over and above whatever narration of fact was stated in his claim petition. Admittedly, the claimant had stated that he had purchased the ticket in presence of villager and had also stated that he would produce witness if required, and ultimately Gulu Das was produced as a witness before the court. This court has gone through the impugned judgment and finds that the learned tribunal has recorded that on the one hand, the claimant in his evidence stated that he was travelling alone, and thereafter, immediately after this answer, he stated that Gulu Das had bought the journey ticket who was travelling with him, and that the name of Gulu Das did not appear in the original claim application, and on this basis has drawn an inference that there are contradictions in the statement. This court finds that the sequence of event as narrated and proved by the claimant before the tribunal was that though he was travelling, he boarded the train with Gulu Das, but at the time of the incident, he was alone, and as Gulu Das had already got down in the previous station at Jasidi. This aspect of the matter appears to have been ignored by the learned court, and the sequence of statement made by the claimant in his cross-examination clearly depicts the actual picture. This court also finds that so far as the statement of so far as the non-mentioning of name of Gulu Das is concerned, the claimant had stated in his claim petition that he was travelling with villager and had also stated that he would produce witness, and no such cross-examination has been made with respect to the claimant regarding non-disclosure of name of Gulu Das in his claim petition, or that he had improved his case by producing false witness of Gulu Das. Rather, the claimant was put a question by the opposite party that the claimant had jumped from the train. But at the time of this cross-examination also, the claimant was not confronted with his previous statement said to have been made at the stage of inquiry. Considering the totality of facts and circumstances, and this court is of the view that the learned tribunal has not appreciated the materials on record properly while coming to a finding, and in view of the judgment passed by the Honorable Supreme Court in the case of Union of India versus Reena Devi, mere loss of ticket may not be a ground to refuse compensation. Although the initial burden is on the claimant, and this can be discharged by filing an affidavit of relevant fact, which has been duly done in the present case, and the evidence of the claimant and his witness Guru Das having remained intact before the tribunal, there was no reason to deny compensation to the claimant. Compensation amount पे तो कोई dispute नहीं. Since there is no dispute so far as the amount of compensation, if the incident was found true, is concerned, even during the course of argument, a specific query has been raised to the counsel for the respondent. He has also submitted that if the court allows compensation, then there is no dispute so far as the quantum is concerned. कहाँ पे कितना claim था आपका? The claim is essentially based on the chart, on the rules. है आपके पास?
Railway accident compensation rules of 1990 was the first one which had enumerated all the
Injuries.
injuries and
Where is which column are you in?
after that
Amputation. For loss of both hands or amputation at higher sides.
the double amputation through leg or thigh or amputation through leg or thigh on one side and loss of other foot. In that case it is
And loss of other foot. For कौन सा होगा बताइए आपका? There is amputation of one leg
one leg.
below the thigh, above the thigh. बताइए कौन सा होगा? कॉलम बताइए.
I am going by amputation through leg or thigh or amputation through leg or thigh.
कहाँ है? कौन सा कॉलम
Amputation
बताइए?
पे हम जा रहे हैं लेकिन डबल amputation
नहीं आप बताइए आपका कौन सा होगा? ऐसे तो नहीं हो सकता ना.
going on part 3 part 2 clause 3
Part 2 clause 3 for double amputation. तो double amputation नहीं है आपका. साइड भी नहीं है. बताइए
amputation at hip हो जाएगा.
कहाँ पर है?
next phrase में amputation at hip. So clause 16. In double amputation पे leadership is not limited to amputation at hip because वहीं से उनका नीचे कर दिया है. 7,20,000.
Amputation above knee है. Amputation at hip नहीं.
Above
आप देखिए अपने क्लेम पिटीशन में क्या लिखा
above
है.
knee है.
हाँ, amputation above knee है तो कौन सा होगा? Below knee है. Amputation below knee है. Amputation above knee कौन सा होगा? Below middle thigh.
Below middle thigh.
2-3.5 feet inch below knee.
Amputation below hip with stump exceeding 5 inches in length measured from tip to great truncator but not beyond middle thigh.
Or for amputation below hip with stump.
not exceeding 5 inches in length measured from tip to great truncator but not beyond middle thigh. This should be the because
For amputation below middle thigh to 3.5 inch नहीं 18 होना चाहिए. Yes?
17 होना चाहिए.
कैसे 17 होना
Below
चाहिए?
hip with stump not exceeding 5 inches in length measured from tip of great truncator not beyond middle thigh. Is that the middle thigh? Upper
कहाँ
thigh?
पर आप बताइए ना कहाँ पर है? You just tell me what is your claim.
इनका जो photo फोटो देखिए ना, उसी में से आपको clear हो जाएगा।
कहाँ है फोटो दिखाई?
तो उसके इसमें क्लेम एप्लीकेशन के साथ फोटो लगा।
एम्पुटेशन का रिपोर्ट बताइए। एम्पुटेशन ऑफ बताइए जरा देख के भाई, ऐसे नहीं, आपको ध्यान देना चाहिए कितना क्वांटम होगा, ऐसे नहीं कर सकते हैं।
लेफ्ट थाई एम्पुटेशन बिलो अपर क्या है इसमें द डिस्चार्ज स्लिप है। I have annexed it and annexed it to report the claim.
आपका क्लेम एप्लीकेशन में कितना है? चलिए क्लेम में क्या लिखें? हाई एम्पुटेशन
Below upper
पूरा नहीं है।
but apparent from the photograph that it is upper thigh, the middle thigh is gone. It is apparent from the photograph.
फोटोग्राफ से देख के हम लोग नहीं कुछ डिराइव करेंगे।
It's apparent.
हाई एम्पुटेशन दिया हुआ।
Thigh amputation में middle thigh, upper thigh सब आ रहा है इसलिए. It is basically वो यहाँ से
क्लेम तो आपको एस्टैब्लिश करना होगा ना, ऐसे फोटो देख के हम लोग नहीं कुछ डिराइव करेंगे।
It is thigh amputation. The thigh amputation I will take it from the पूरा ही thigh चला गया. The doctor's report is left thigh amputation. When thigh amputation means then that entire leg is gone. Left thigh. The thigh starts just from the hip.
18 से ज़्यादा का क्लेम
18 and 19 below, either 18 or 19.
फॉर एम्पुटेशन बिलो मिडिल थाई, 2.5 बिलो नी।
So amputation below hip with stump not.
ये दोनों है।
Stump is 5 inches. For stump 5 inches stump इसका वही दिख रहा है. On hip stump is 5 inches in length measured from tip to great trangenter but not beyond middle thigh. Not beyond middle hip का तो middle thigh भी चला गया है. It's amputation of the thigh.
Considering the nature of injury, the claimant would be entitled for compensation as per Rule 3, Part 3, within bracket 18.
At least 17.
So far as the notification is concerned, the election policy, it's from 22nd December
Sir, अभी हो गया.
कब का है ये?
22 December.
Previously has clarified that also. In that
And
what
the
happens is that
incident is the 12th December. So earlier,
The incident is prior to that.
incident is prior to that. Prima Devi has clarified on that.
Where is that?
15.4.
That it will be applicable irrespective of the date of
It
accident.
will be on the whichever is higher on the date of judgment, that amount. If there is a
कहाँ है बताइए मैडम, क्या कंफ्यूजन में मत रखिए।
15.4.
आप पहले का भी तो नहीं लेके आए हैं ना, नोटिफिकेशन लाए हैं पहले का?
का 4 लाख. In case of death,
कहाँ से बोल रहे हैं?
नहीं पहले का notification नहीं.
15.4 बताइए।
Accordingly, we conclude that compensation will be payable as applicable on the date of accident with interest as may be considered reasonable from time to time on the same pattern as in accident claim cases. If the amount so calculated is less than the amount prescribed as on the date of award of the tribunal, the payment will be entitled to either of the two amounts. This order will not affect the amounts which have already become final and by limitation for challenging such amounts as expired. This order will not by itself be allowed for combination of period. Single conflict will not
इसमें से भाई आप जो जहाँ से ये साइटेशन निकालते हैं ना, इट इज़ नॉट पॉसिबल मैडम, आपके पास SCC नहीं है, AIR नहीं है, कहाँ से भी ऐसा निकालते हैं? Usually it doesn't have a proper paragraph numbering. We are not able to find out कहाँ से आप पढ़ रहे हैं. बताइए कहाँ से पढ़ रहे हैं? ऐसे नहीं citation दिया करिए. These citations are not acceptable in court of law. Are you aware of it? Are you aware or you are not aware? ऐसे YouTube से निकाल के आप citation मत दिया करिए. उसका equivalent जो है उसको लेके आया करिए. वहाँ मार्क करके दीजिए. ना प्रॉपर पैराग्राफिंग होता है. पैराग्राफ के बीच से एक पैराग्राफ शुरू हो जाता है. जितना गरीब आपका क्लाइंट है उसको और गरीब मत बनाइए. पढ़िए इसको.
Accordingly, we conclude that compensation will be payable as applicable on the date of accident with interest as may be considered reasonable from time to time in the same pattern as in accident claim cases. If the amount so calculated is less than the amount prescribed as on the date of award of the tribunal, the claimant will be entitled to higher of the awards. This order will not affect the awards which have already become final, and the limitation for challenging such awards is expired. This order will not by itself be a ground for
इसको हम चेक करेंगे उससे, तभी हम इसको अप्लाई करेंगे. नहीं तो नहीं करेंगे. नहीं तो पुराना वाला पे हम बोल देंगे उसी पे काट देंगे. Because this is, I have to check it from proper citation. I will check it from proper citation. अगर ये applicable होगा, you will get it at clause number 18.
Clause number 18, it will be either whatever will be in this case.
I will give you at clause number 18.
17. For application below it.
At clause 18.
Not exceed. In his case, in that situation, it will be whatever the amount.
एक सेकंड. आपका रिप्लाई भी तो फाइल हुआ होगा ना वहाँ पर. क्वांटम पर कुछ रिप्लाई फाइल की होगी ना. Written statement.
Since it was rejected, we probably it was. उस पर reply नहीं.
उस पर रिप्लाई नहीं है, लेकिन क्वांटम तो जितना 8 लाख मांगे थे उतना तो नहीं बनता है. High amputation.
Please 17th accommodation below hip with stump not exceeding 5 inches in length measured from tip to great tractor but not beyond.
आप अपने इंजरी रिपोर्ट से दिखाइए ना. If you want to claim in a particular category, you have to show it from the injury.
Injury of amputation of thigh. So when I'm saying amputation of thigh, that means it has come. It is the entire thigh has gone. It is below hip.
Seventeen, right? Subject to my verification from the
Now in this
notification.
case, it will be the old railway compensation rules 19 since the accident was of 12/12/16 and this notification has come on 22/12/16 with effect from 1/1/2017.
Oh, बहुत close है.
Both closer, but even if we are going strictly by the order of the Honorable Apex Court. In this case, it will be the older amount with interest or 640. It cannot be less than 640. If the interest amount which your ladyship is giving to this person, this injured person, is more than 640, the amount is more than 640, then higher will be there. But if the interest amount and the amount that was there is lower than 640, then he is entitled to 640. It's the higher of the two amounts.
Higher the two amount. It means that from the date of incident plus interest, or 640, whichever is highest. Right?
Yes.
After calculating the interest,
Yes, yes. If it is less than 640.
increase मिलो the 640 मिलो then
Previous
that
amount
will
was 3,20,000.
तो आपको तो 2016 से ही मिलेगा.
3,20,000 was the
No,
previous
इसमें
amount. 3,20,000 was the previous amount. So whatever interest your ladyship gets, if the amount comes to less than 640, he will get 640.
Interest is also not prescribed.
Interest is on an average we have seen it depends upon the interest is 7% or 9%, 12%. It depends upon the tax to tax, and it depends upon interest is not prescribed under the
Is not prescribed.
not prescribed under the
But in
act,
some
but
cases
it
मिलो the 7%, in some cases 8%.
is, it is again it is
It has been
governed by the
submitted by the
decision of-
learned counsel for the appellant that the date of incident is 12/12/2016 and the new notification has come with effect from 1st of January 2017 by virtue of Gazette notification dated 22nd December 2016. She has submitted that no fixed rate of interest has been prescribed and it is essentially the discretion of the court so far as compensation is concerned. She submits that if the court awards 7% interest or whatever the court feels and the computation with interest exceeds the amount prescribed through the aforesaid notification of 1990, then the claimant would be entitled to that amount. But if it is less than the amount prescribed under the notification, then the claimant would be entitled to the amount mentioned in the notification. Right?
not the 1990 the new
आपको जजमेंट भी नहीं लेके आप सोचे कि नहीं होगा, ऐसा सोच के आए.
ऐसा कुछ नहीं सोचा है.
तो फिर क्या सोच के आए? कंप्यूटेशन का कुछ सोच के ही नहीं आए.
Computation का हम
640
double
is
application-
below the amount below which is higher. Then upon 640 below, no interest.
Yes, yes.
Yes, no
Then 640 no interest was given.
It is the higher of the two amounts.
This appeal is allowed in the aforesaid terms. वो हम चेक करके बताएंगे, ठीक है? थोड़ा सा आपको देखना पड़ेगा.
15.4 पे ही मिलेगा. 15.4 is the
We will see. पुराना नोटिफिकेशन भी प्रोवाइड कर देंगे प्लीज, ठीक है? उसमें भी वो कॉलम मार्क करके काइंडली प्रोवाइड इट टू मी बाय टुमारो. यू कैन जस्ट प्रोवाइड इट.
act पे पुराना act पे भी लिया हुआ है.
दिखाई दे निकासी.
Accident and compensation rules 1990.
Item 1, second appeal 1 to 7 of 2019.
This has been substantially argued by both of you. You just give me those citations. We just wanted to give those citations. और थोड़ा सा ब्रश कर लेंगे, बहुत दिन हो गए सुने. Let us see the accused judgments. You are the defendant.
I was the plaintiff.
You were the plaintiff.
Defendant went in appeal and the suit was reversed.
Okay. Okay, you were the plaintiff and it got satisfied prior to institution of the appeal.
At least a year before this institution of
So
the
at the time of condonation of delay, you did not oppose.
we made an opposition and we lost before the appellate court. We came to the high court also. Here also the order of the appellate court condoning the delay was
Was sustained.
sustained.
So, first, so far as this aspect is concerned, give me certain dates. When was the trial court judgment passed?
High court judgment is dated 25th January 2006.
25/1/2006. Decreed. Right?
I'm sorry, madam.
It was decreed.
Decreed on
That's
8th,
right.
8th February 2006. Decree prepared on 8th February 2006.
8/2/2006.
No, I'm sorry, madam. 25th January. Yes, that same day.
Judgment and decree.
Yes.
And then it was satisfied when?
It was satisfied. Seven 9/2006.
7/9/2006. It was done by the process of court.
Yes.
Execution case number?
10 of 2006.
Case number 10 of 2006. Very good. When was the appeal filed?
15/9/2007.
15/9/2007. Barred by how many days? Appellate court का दिखाइए.
20 months approximately. January 2006 to September 2007.
About 20 months. When was the delay condoned? By which order? Appellate court, correct. The suit proceeding was contested or ex parte?
Contested.
Contested. Okay, sir. appellate court का रिकॉर्ड होगा ना.
Twelve to 2008, the delay was condoned by the appellate court.
12 to 2008. Primarily on medical grounds.
I'm sorry, ma'am?
On medical grounds.
Yes. 70 years old age man.
Yes. Then in writ petition you had come over here.
Yes. Writ petition number.
What was the writ petition? 1880 इसका जरा ऑर्डर का कॉपी दीजिए 1880 of 2017
That was probably with respect to the admission of the additional evidence by the applicant in 2017.
that was allowed or dismissed
That remained pending. I presume that it is still pending.
देखिए जरा स्टेटस बताइए
Second.
नहीं WPC number 1880 of 2017 that was allowed. This writ petition was allowed. I don't know. पता नहीं चल रहा.
I checked.
आपने इस डिले कॉन्डोनेशन के अगेंस्ट में भी कुछ फाइल किया था. कौन सा writ petition? मिला आपको writ का order? दीजिए. और तो कोई रिट का कोई रेफरेंस नहीं आ रहा. पेंडिंग है. ये किस लिए आप रिट फाइल किए थे?
I'm sorry.
किस लिए रिट फाइल?
That order of the appellate court admitting additional evidence.
Additional evidence was admitted.
Yes.
So what was the nature of additional evidence?
All the documents were prior to the decree and judgment of the trial court.
No, that is not a substantial question of law. We want to know what was the nature of additional evidence.
Additional evidences were some orders of the Calcutta High Court with respect to the probate, which was subsequently recalled and converted into a contested suit. So probate was granted in.
So your judgment was, trial court judgment was based on probate?
It was the agreement was based on the performance by the defendant if he is granted the probate. So probate was granted in 93.
And that was executed thereafter, after
And-
grant of probate.
And after grant of probate, when he, as per the case of the plaintiff, when he did not execute the said deed, I filed the suit.
That's right. And thereafter, in the meantime, that was recalled.
Yes, there was some dispute among themselves in the co-partners. They entered and contested, and it was
So therefore, the probate which was granted did not exist legally at the stage of appeal.
at the stage of appeal. In fact, even
And
at the stage of
ultimately, that case has been settled. Probate.
suit is pending among the co-partners.
ठीक, वो सूट अपना चल रहा है, लेकिन प्रोबेट एज ऑन डेट नहीं है.
Probate has not been.
अब आप हमको बताइए कि जो आप जजमेंट्स प्रोड्यूस करना चाह रहे थे. डेट ऑफ प्रोबेट बताइए.
Seven 993.
उसके बाद क्या हुआ?
Then I filed the suit.
प्रोबेट होने के बाद
The condition of the contract was that when the owner will get a probate, only then he will be.
ये प्रोबेट केस कैसे सूट में कन्वर्ट?
No, that is similar to intersect between the co-partners. I am nowhere in that. ये उनके co-partners आए, they started contesting upon their own rights and interest in the property.
आपका पार्टीशन सूट चल रहा है, क्या चल रहा है?
Partition in between the brothers and sisters.
This probate is intact.
No, it has been revoked. It has come in the impugned order. It has come in the impugned order.
कब रिवोक हुआ? डेट बताइए.
Below failed to consider. It has come in page number 40 मिला.
डेट बताइए.
हाँ,
We will
10
trust
आठ
you.
दिन
1989.
हाँ नहीं 1999 10/8/1999.
उसके बाद प्रोबेट पर कोई कंटेस्ट नहीं हुआ.
नहीं उसके बाद रेगुलर कन्वर्ट हो गया.
अच्छा वो कन्वर्ट हो गया.
कन्वर्ट हो गया.
टाइटल सूट नंबर बताइए.
Title suit number 2 or 2000.
Two of
2000. Page 42.
which is pending. Which is pending.
Pending. It's
Before the convert.
Before
नहीं बंगाल.
कहीं पर भी होता होगा. ठीक है, आप बताइए. Substantial question of law number 1. You were supposed to give some judgment on this.
Yes.
इस citation को पता होगा आपको?
On the first issue, whether in a suit of a specific performance there cannot be a judgment of reversal of the decree of trial court stands satisfied by exclusion through the process of court even prior to the institution of appeal, and there does not exist any decree in the eyes of law to be set aside, reversed, the order of the trial court reversed by the appellate court. That my lord, I am reading the order of my lord dated 25/3/2025. Where my lord
Yes.
Now, my lord, on this particular issue,
You were supposed to cite any citation, right? You remember? That is
Yes, my
the
lord, I
last line of the order.
my lord,
Judgment आप cite करना
my lord,
चाहते
on this particular issue, I couldn't lay hand on this aspect.
हैं. Number 1, no judgment as such.
No judgment.
आपके पास कोई judgment है? मेरे ना टेबल पर एक फोल्डर में 2 judgment रखा है. देखो.
appellate court's judgment is well written, well versed.
आपसे पूछ रहे हैं क्या इस पर कोई judgment है?
इस पर
हाँ. Substantial question of law number 1 पे आपको कुछ judgment cite करना है. और बताइए further. किसी भी point पर आपको कोई judgment cite करना है?
Yes, my lord. Second point.
Second.
First. 2018 for SEC 659. 2014, 18 for SEC 659.
Additional evidence का फाइल हुआ
At the appellate stage,
When?
that was the date is 2/2/2015 and allowed on 21/11/16. And
just a moment. Allowed on
allowed on 21/11/16.
you were supposed to file your rejoinder. Did you file or you did not file?
We contested. We opposed it.
Where is your rejoinder? Did you admit this fact or you did not admit this fact?
I did not admit the fact.
You did not admit the fact that the probate has been revoked.
No, because I had no litigation personally, as I was not a party to the
The order was produced before the court.
order was filed before the court. And it
Was there any allegation that it is a forged document? Because it's a court order.
my lord.
So there is no allegation of any forgery.
But on that particular aspect, I don't have my pleading complete. I may not be able to answer much on the issue. What was the
A
objection
certified copy,
taken,
what
save
can
and
you answer
except
to
which is
that?
reflected from the order sheet of the appellate court.
At page 42, you have technically 9 of this by appellate. It has been incorporated.
The judgment
At
At
page
page
number?
42. It has been incorporated. You are waiting it.
42.
Yes. Daily order sheet dated 21/11/2016 of the appellate court.
Page 42, it has been mentioned that whether the suit property could be transferred in spite of injunction. Page 42, internal page बताइए.
Internal page 9.
9.
Internal page of the appellate court. और running page 42 में है.
Exhibit A.
Yes, Exhibit A is the original status report of the title suit number so and so, so and so. Exhibit B is the certified copy of order dated 10th August 19 passed by Honorable Justice so and so of Honorable Calcutta including title suit number so and so. Exhibit C is the certified copy of order sheet of the now then
The judgment passed by the trial court was 25/1/2006.
yes,
And this probate was revoked on 10th of August 1990.
Yes.
Prior to that,
yes, but
they were relying upon the probate.
only provided but later on it has been given. And it was informed in the year 1994 it has been informed to the plaintiff by way of advocate notice.
There was an ad interim injunction also granted on 10/8. And ordered that the ad interim injunction shall continue and the same shall abide by the result of testamentary proceeding.
Yes.
That's right. So, which judgment are you relying upon?
Lord, those judgments which I have tendered,
Yes, you just place one by one.
yes. Milord is having 2018 for SEC 659.
Yes.
Milord, may I take Milord's to paragraph 14. Order 41 rule 2 provides that applicant shall not, except by leave of the court, be allowed to urge any ground in appeal which is not set forth in memorandum of appeal. Then, Milord, last 4 lines may I take note of that paragraph on that page. When the appellate court admits the additional evidence under Order 41 Rule 27, we fail to see any reason for not following the same course of granting opportunity to the contesting party, which may be affected by acceptance of additional evidence. So I was not granted, and on the next page,
You read it. You पढ़िए आप आधा sentence मत पढ़िए. In the present
in
case.
the present case, additional evidence which were brought on record were registered sale deeds, which were executed by the present appellant and his other co-sharers. And what was relied on before the High Court was that the appellant admitted in the sale deeds that partition has taken place in the family. The main issue in the first appeal before High Court was as to whether the finding of the trial court that no partition by means and bounds has taken place in the family is correct or not. The additional evidence which was admitted has been relied on by the High Court while allowing the appeal. It was in the interest of justice that High Court ought to have allowed opportunity to the plaintiffs, who were respondents in the first appeal, to either lead an evidence in rebuttal or to explain the alleged admissions as relied by the defendants. The mere fact that no counter affidavit was filed to the IAS was not decisive, since IAS having not been admitted, occasion for counter affidavit did not arise at any earlier point of time. The High Court on the same day has allowed the IAS as well as the first appeal. The fact that the contesting respondents to the first appeal who are the appellant before us were not represented at the time of hearing of the first appeal was not a reason for not giving opportunity to them to lead evidence and rebuttal. A 3-judge bench of this court in so had occasion to consider Order 41 Rule 27 in context of admission of additional evidence by the appellate court. This court has observed that in the event the High Court admits an additional evidence, an opportunity should have been given to the other party to rebut any inference arising from its existence by leading evidence. In para 28 of the judgment, following has been laid down. The Karnataka High Court had, however, not complied with the provisions of Order 41 Rule 27, which require that an appellate court should be satisfied that the additional evidence is required to enable it either to pronounce judgment or for any other substantial cause. It had recorded no reasons to show that it had considered the requirements of Order 41 Rule 27 CPC. We are of the opinion that High Court should have recorded its reasons to show why it found the admission of such evidence to be necessary for some substantial reason. And if it found it necessary to admit it, an opportunity should have been given to the appellant to rebut any inference arising from its existence by leading other evidence. So that is one point of necessity of opportunity for rebuttal. And 2019-12 SCC page 366. I'm sorry, Milord.
Yes. 2019. Yes.
12 SCC page 366.
Para number? Which para?
I'm sorry, Milord, it has been only tendered. It doesn't speak much about additional evidence. My Lord, may kindly come to 2018 9 SCC page 445.
2000?
18 9 SCC page 445.
Para
Para 13, 14 and 15. May I start from para 12? In our considered opinion, the first appellate court committed two jurisdictional errors in allowing the appeals. First, it took into consideration the additional piece of evidence while deciding the appeals on merits without affording any opportunity to the appellants herein to file any rebuttal evidence to counter the additional evidence produced by the respondents. This caused prejudice to the appellants herein because they suffered the adverse order from the appellate court on the basis of additional evidence adduced by the respondents for the first time in appeal against them. Second error was of procedure, which the first appellate court failed to resort in disposing of the appeal. This also involved a question of jurisdiction. Having allowed CMP number so-and-so and in our opinion rightly, the first appellate court had two options. First, it could have either set aside the entire judgment and decree of the trial court by taking recourse to the provisions of Order 41 Rule 23A of the court and remanded the case to trial court for retrial in the suits so as to enable the parties to adduce oral evidence or prove the additional evidence in accordance with law. Or second, it had an opinion to invoke powers under Order 41 Rule 25 of the court by retaining the appeals to itself and remitting the case to the trial court for limited trial on particular issues arising in case in the light of additional evidence which was taken on record and invite findings of the trial court on such limited issues to enable the first appellate court to decide the appeals on merit.
Then,
Then we got, this is AIR 2020 Supreme Court 3102.
which panel?
Let me kindly come to internal page 31. This deals with Order 41 Rule 23 and Rule 25, and also as to what should be the course of action by an appellate court when taking additional evidence. Taking up the other point for determination, I am reading paragraph 25 at page 31. The submission of learned counsel for the appellants that High Court ought to have considered remanding the case by taking recourse to the provisions contained in Order 41 Rule 23 CPC in our view remains totally bereft of substance. This submission has only been noted to be rejected. The procedure relating to appeals from original decrees is provided in Order 41 of the Code of Civil Procedure 1908, and therein various provisions relating to hearing of an appeal, remand of the case, remitting of issues for trial, production of additional evidence in appellate court, etc. are contained in Rules 16 to 29 under the subheading Procedural on Hearing. For their relevance, we may take note of the provisions contained in Rule 23, 23A, 24 and 25 of Order 41 CPC as follows. Rule 23, remand of case by appellate court, where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issue or issues shall be tried in case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, with directions to readmit the suit under its original number in the register of civil suits and proceed to determine the suit. And the evidence, if any, recorded during the original trial shall, subject to all just exceptions, be evidence during the trial after remand. 23A, remand in other cases. Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal, and a retrial is considered necessary, the appellate court shall have the same power as it has under Rule 23. Where 24, where evidence on record is sufficient, the appellate court may determine case finally. Where the evidence upon record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after settling the issues if necessary, finally determine the issue notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded only upon some ground other than that on which the appellate court proceeds. 25. Where the appellate court may frame issues and refer them for trial to court whose decree appeal from, where the court from whose decree the appeal is preferred has omitted to frame or try any issue, or to determine any question of fact, which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for the trial to the court from whose decree appeal is preferred, and in such case shall direct such court to take additional evidence required, and such court shall proceed to try such issues, and shall return the evidence to the appellate court together with its finding thereon, and the reasons thereof for, within such time as may be fixed by the appellate court or extended by it from time to time. Rule 23A came to be inserted in Order 41 CPC by way of Code of Civil Procedure Amendment Act 1976. Prior to this amendment, it was generally accepted by the courts that although under Rule 23 an order of remand could be made only on reversal of a decree disposing of suit on preliminary point, but appellate court has inherent power of remanding a case where it was considered necessary to do so in the interest of justice. Some of the high courts had made similar provisions by way of respective amendments. Insertion of Rule 23A in Order 41 by the Amending Act of 1976 makes it explicit that even when the suit has been disposed of otherwise than on preliminary point and the decree is reversed in appeal, the appellate court shall have the power of remand if a retrial is considered necessary. A comprehension of the scheme of provisions for remand as contained in Rule 23 and 23A of Order 41 is not complete without such powers of remand as provided in Rule 23 and 23A of Order 41 are different than the power of appellate court to remit an issue for finding under Rule 25. The power of remitting is ordinarily to be resorted to when the trial court has omitted to try any material issue or to determine any question of fact. In other words, the proper procedure in a case where trial court, while disposing of the suit on merits, had failed to determine one or more of the material issues questions is to remit the issue of the questions under Rule 25 and not to remand the whole case for retrial. Ordinarily, in case of an order under Rule 25 of Order 41, the matter is retained on the file of appellate court and only the issue of the questions are remitted to the trial court for findings. On the other hand, when an order of remand is made under Rule 23 or 23A, the whole case goes back for decision to the trial court except on the point on which appellate court has returned concluded finding, if any. While making a remand under Rule 23 or 23A, the judgment and decree of the trial court is required to be set aside, but it is not necessary to set aside the impugned judgment and decree when taking recourse to Rule 25 of Order 41. Reference to the provisions contained in Rule 24 and Order 41 that enables the appellate court to dispose of a case finally without a remand if evidence on record is sufficient, notwithstanding the appellate court proceeds on a ground entirely different from that on which the trial court had proceeded. There are two more paragraphs. One is a larger one, 25.4, and then two-line paragraph on the next page. Met placement. A conjoint reading of Rule 23, 23A and 24 of Order 41 brings forth the scope as also contours of the powers of remand, that when the available evidence is sufficient to dispose of the matter, the proper course of an appellate court is to follow the mandate of Rule 24 Order 41 CPC and to determine the suit finding. It is only in such cases where the decree is challenge is reversed in appeal and a retrial is considered necessary that the appellate court shall adopt the course of remanding the case. It remains right that order of remand is not to be passed in a routine manner because an unwarranted order of remand merely elongates the life of litigation without serving the cause of justice. An order of remand only on the ground that points touching the appreciation of evidence were not dealt by the trial court may not be considered proper in a given case because the first appellate court itself is possessed of jurisdiction to enter into facts and appreciate the evidence. There could, of course, be several eventualities which will justify an order of remand, or where remand would be rather necessary depending on the facts and given set of circumstances of a case. The decision cited by the learned counsel for the appellant in the case of Mohan Kumar Supra is an apt illustration as to when the appellate court ought to exercise power of remand. In the said case, the appellant and his mother had filed civil suit against government and local body seeking declaration of title, perpetual injunction, and for recovery of possession in respect of the land in question. The trial court partly decreed the suit while holding that the plaintiffs were owners of the land in dispute on which trespass was committed by the respondents, and they were entitled to get encroachment removed, and it was also held that government should acquire the land and pay market value of the land to the appellant. Such part of the decree of the trial court was not challenged by the defendant, but as against the part of decision of the trial court which resulted in rejection of the claim of appellant for allotment of an alternative land, the appellant preferred an appeal before the High Court. The High Court not only dismissed the appeal so filed by the appellant but proceeded to dismiss the entire suit with the finding that the plaintiff appellant had failed to prove his ownership over the suit land inasmuch as he did not examine the vendor of the sale deed. In the given circumstances, this court observed that when the High Court held that appellant was not able to prove his title to the suit land due to non-examination of his vendor, the proper course of the High Court was to remand the case to the trial court by affording an opportunity to the appellant to prove his title by adducing proper evidence in addition to what had already been adduced. Obviously, this court found that for the conclusion reached by the High Court, a case of retrial was made out, particularly when the trial court had otherwise held that the appellant was owner of the land in dispute and was entitled to get the encroachment removed as also to get the market value of the land. Such cases where retrial is considered necessary because of any particular reason, and more particularly for the reason that adequate opportunity of leading sufficient evidence to a party is requisite, stand at entirely different footings than the cases where evidence has already been adduced and decision is to be rendered on appreciation of evidence. It also remains right that an order of remand is not to be passed merely for the purpose of allowing a party to fill up the lacuna in its case. It gets perforce reiterated that occasion for remand would arise only when the factual findings of the trial court are reversed and a retrial is considered necessary by the appellate court. I'm not taking cue from these two judgments, that is of the AIR which I just read, and 2018 9 SCC 445. There are two procedural errors committed by the appellate court while allowing the appeal. The first error is that no opportunity of rebuttal was granted to me after taking the additional evidence. And by taking the additional evidence on record, the appellate court delved into a factual aspect which was not before the trial court itself. So a new fact was introduced by virtue of the additional evidence, and it would have been tried for the first appellate court to remand the matter for retrial if at all the additional evidence was found to be admissible. Now, on the admissibility of additional evidence, if Malad may kindly see the provisions of CPC, when an additional evidence can be taken into consideration, the concerned provision of law.
So you say there are two procedural errors. No opportunity of rebuttal was granted
Yes.
after the additional evidence was taken into consideration. The law is that the first appellate court has to pass the final order on additional evidence at the pronouncement of final judgment. They will give you an opportunity to respond to the additional evidence, and then they will pass an order. Whether it has after rebuttal, they may pass an order regarding additional evidence, and then ultimately it has to be considered at the later stage. And this addition of additional evidence which was considered after hearing both of you, that an order was drawn against which a writ was filed, and that is pending. But ultimately the additional evidence has been dealt with only at the final stage of the judgment, in the final order.
The additional evidence has been admitted by the appellate court prior to that, by the order
After giving you opportunity.
of opposition,
Certainly.
not of rebuttal, opposing the order 41 rule 27 petition. But after having allowed that petition, I ought to have been given an opportunity of rebuttal also. So 21/11/2016 is the date when the additional evidence petition was allowed by the appellate court.
You see, the judgment of Supreme Court says that whether the additional evidence will be taken into consideration or not, that has to be ultimately decided at the time of final judgment. Right? That idea of additional evidence will be decided at the time of final judgment. So when that will be decided at the time of final judgment, so whatever rejoinder or counter you are filing to additional evidence is an opportunity of rebuttal. That you are opposing that suppose there is a certified copy as filed and it is forged. You can say that this is not the certified copy, this is forged, or maybe that this has been set aside by a subsequent judgment. It is quite possible. So these things has to be taken care of at the time when you file your counter affidavit to the additional evidence. That is the opportunity of rebuttal. If you dispute it, there are 2-3 kinds of situations. If you dispute the existence of a document, If you dispute the existence of a document, then the court will see whether this document is to be proved in accordance with law.
My lord will appreciate, my lord, what I intend to
And
develop
if,
in my
and if you
argument.
and if you do not dispute the existence of a document, a judgment relied upon at the stage of trial court is ultimately set aside, maybe at the appellate stage, or maybe even prior to filing of the judgment of the trial court. That cannot be ignored and brushed aside in this matter,
My lord,
isn't it?
my submissions.
The additional documents which they filed, did you raise any dispute that they do not exist, or they have been set aside because what they were filing was the copy of the orders?
My lord, the judgments of the Honorable Supreme Court, which I have relied upon before and placed before my lord, they, my lord, indicate that it is not that I have to take the first stand, but rather the onus is upon the first appellate court to provide an opportunity of rebuttal to the other side, if the evidence are to be considered while, my lord, passing the judgment. So after passing of the order, allowing the petition order 41 rule
Anyways, got
27,
it. So according to you, there are two procedural errors. One is there is no opportunity of rebuttal. Other is, you said 2 points.
the, my lord, it would
No
have been tried.
opportunity of rebuttal.
It would have been tried for the appellate court to remand the matter to the trial court.
Appellate court ought to have remanded the matter.
If it finds that these evidences are necessary for adjudication in the interest of justice. So, if my lord, my submissions are that order 41 rule 27, if my lord may kindly see the language of it. The
We have
parties-
seen it, we have read the judgment you have cited. The provisions are also quoted. The provisions are also quoted in the
Order
judgment.
27 I have not placed. I have placed 23, 23A, 24 and 25.
You are referring to order?
41 rule 27.
This is additional evidence.
Additional.
This is also quoted in the judgment. You have read it. It is quoted, as I remember.
The AIR judgment, my lord, which I relied, my lord, that is primarily on the course of action to be adopted by the appellate court after order 41 rule 27.
One of these judgments are missing. We come across this provision every day. You just tell us what do you want to
Yes,
say
ma'am.
on
I
this.
intend to say, my lord, that the opening line of rule 27 says that additional evidence shall not be permitted. So, my lord, it is not a right of the appellant to lead additional evidence. And when it can be permitted, my lord, conditions are that the trial court has refused to admit the evidence, and if the appellate court finds that the refusal was not proper, then it can be taken. The party seeking to produce additional evidence establishes that notwithstanding exercise of due diligence, such evidence was not within his knowledge. But that is also not the case of the first appellant. And the last note says, the appellate court may allow such evidence or document to be produced. Appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. Now, my lord, this 27B is not the case where, my lord, if my lords may kindly see the order of the first appellate court dated 21/11/2016 when the petition for order 41 rule 27 was allowed. What the first appellate court holds while allowing the petition, if I may place, my lord, only the finding part. Heard both the parties and perused the material available on record. It transpires that this case relates to property in Devghar town in which plaintiff Ajay Kumar Verma was a tenant and the house belonged to one late Kamala Prasad Roy. Defendant Dilip Kumar Roy is the son of late Kamala Prasad Roy. The defendant claimed exclusive title over the aforesaid house of his father on the basis of last will of his father, which was claimed to have been executed in his favor alone. On the basis of the above title, an agreement for sale was entered between the plaintiff and the defendant, for which defendant had received advance from the plaintiff. Dispute arose between both the parties regarding non-execution of sale deed, non-payment of balance amount. In the meanwhile, when the will was filed before the Honorable Calcutta High Court for getting probate, then the same was contested by the sisters of the defendant, namely Dilip Kumar Roy, and the probate case was converted into title suit. Injunction was passed by the Honorable Court which was subsisting during the pendency of the
Which
suit.
page are you reading?
My lord, I am reading the daily order sheet of the appellate court, that by which the order 41 rule 27 petition was allowed by the appellate court.
Yes, please. What is the ground to allow that?
That is, my lord, I am placing before my lord. Before the Calcutta High Court, the brother and sisters were parties, whereas at Devghar, the brother and purchaser of the property are parties. Though parties were different in these two litigations, but both these suits relate to the same property at Devghar. The plaintiff do not deny that no injunction was passed by the Calcutta High Court, but it states that the same was vacated in the time of final disposal of the case. On the other hand, the appellant submits that injunction passed by the Calcutta High Court was not only passed during the pendency of the suit at Devghar, but the same was brought to the notice of learned Sub-Judge Devghar by filing written statement dated 27/4/98 by the defendant appellant. The impugned judgment passed by learned Sub-Judge has not given any finding with regard to such injunction. If any order has been passed during the subsistence of injunction order by a competent court, then it is an illegality. Besides, all the documents which the appellant intends to bring on record are related to the court's order and proceeding with regard to the same piece of property which is the subject matter of dispute in this court as well as Calcutta Court. Besides, all these documents are public documents. They appear to throw light on the subject matter of dispute. If filing of related papers are denied to be adduced as additional evidence, then there is also likelihood of filing of multiplicity of cases. For the reasons stated here above, I have reached to a finding that it is justifiable to allow the petition of the appellant as such petition dated such and such under order 41 rule 27 read with section 151 CPC filed by the appellant is hereby allowed. The appellant is directed to take steps for exhibiting the documents as per law. So, my lord, A and B, A and double A clauses are not made out. And my lord, it is not the case of B where the court on its own finds that certain evidences, oral or documentary, are required for proper adjudication and some substantial cause. And it was, my lord, indicated by the this appellant before the appellate court also that injunction at the time of final judgment by the trial court did not exist. Now these are, my lord, matters which required an opportunity of rebuttal, but after, my lord, granting the opportunity to the first appellant before the first appellate court to take steps for exhibiting the documents, the court proceeded on for hearing and finally passed the judgment of decree during the pendency of the writ petition before this one. On this count, if I may, my lord, place one last judgment of the Honorable Supreme Primarily, my lord, this judgment of Honorable Supreme Court in 2012 8 SCC page 148. It deals with, my lord, power of the appellate court to take additional evidence and circumstances when such additional evidence can be taken. And it indicates that the law does not permit additional evidence in the appellate stage except for the exceptions provided therein. The paragraphs, please to note take provisions of 30 and 36 to 70 of this judgment. 2012 8 SCC 148. In Nagubai Amal versus B. Samarao, this court held that admission made by a party.
See, you can't read a judgment like this. There are so many citations given, and you want to read. You read the entire text. Then you come to the crux of the matter. What the Honorable Supreme Court has decided. Honorable Supreme Court is discussing in the paragraph that you have mentioned is discussing many previous judgments. So what is the conclusion? You just can't read the entire text of the judgment of the Honorable Supreme Court.
Conclusion is that
you refer to the
Order
conclusion.
41 Rule 27 of CPC is not a matter of right. the additional
इसलिए आपको
evidences
कोई
are,
जजमेंट देने की जरूरत नहीं है. It is not a matter of right. There is no doubt on that.
and
Which paragraph are you referring to? You just refer to one paragraph.
para 48.
Paragraph 48.
May it please. To sum up on the issue, it may be held that an application for taking additional evidence on record at a belated stage cannot be filed as a matter of right. The court can consider such an application with circumspection provided it is covered under either of the prerequisite conditions incorporated in the statutory provision itself. The discretion is to be exercised by the court judicially taking into consideration the relevance of the document in respect to the issues involved in the case and the circumstances under which such an evidence could not be laid in the court below, and as to whether the applicant had prosecuted his case before the court below diligently, and as to whether such evidence is required to pronounce the judgment by the appellate court. In case the court comes to the conclusion that application filed comes within the four corners of the statutory provision itself, the evidence may be taken on record. However, the court must record reasons as to on what basis such an application has been allowed. However, the application should not be moved at a belated stage. So, the order allowing order 41/27 petition does not deal with the two provisions which the appellant before the first appellate court could have taken as a ground for leading the evidence, because these grounds were not available to them. The trial court did not refuse. Neither it is a case that they couldn't lay hands over the judgments on issue at the stage of trial, or it is a subsequent. Similar, at the initial submissions being made by me, my lords had opined that the circumstances had changed by virtue of the revocation of the probate. My lord, I'll give a judgment to
We shall
the.
continue in the second